Yesterday, I think, yesterday in the sense, in the last class, we are discussing what is a confession and what is an admission. Today, I think we can discuss an altogether different area, an area exclusively within the domain of court. So who is a witness? Who can testify? And what we mean and understand by the word examination of witnesses. From time immemorial, we know that witness play the most crucial, the most important role in deciding the fate of a dispute. So whenever there is a dispute, definitely the interesting parties, whether they are plaintiff or defendant, whether they are accused or state, must have their own version. So when I am saying something, I am always saying to support my contention or my views. The opposite party always says something that is his case or against my own pleadings. So there must be some independent, impartial person who see the incident or who are witnesses to the fact in issue. So who is a competent witness under Indian Evidence Act? In this regard, I am inviting you to chapter 9 first, section 118. Who may testify? This is what section 118 says. First of all, before going into the examination of witness, we must have an idea about who is a witness and who cannot be compelled to be witnesses. Both are important before proceeding with the second layer, examination of witness. That is why I am starting from the word witness. Is there any class regarding this area? Is there any class regarding the examination of witness in this area? No, thank you. So section 118 says that who may testify? All persons shall be competent to testify unless the court considered that they are prevented from understanding the question put to him or from giving rational answers to those questions by tender age, extreme old age, disease, whether of body or mind, of any kind. So what section 118 broadly says is that every person, irrespective of their age, irrespective of their gender, irrespective of their mental capacity, can reasonably be considered as witness. The only objection the court raises a person who is unable to understand the question put to him. A person who is unable to understand the question put to him means usually he is an idiot or not necessarily be an unsound man. An unsound man of different degree, some person can understand the question put to him, but he may not be able to give a rational answer to all the questions. It doesn't mean that a person suffering from certain kind of mental incapacity is completely precluded from giving answer. Similarly, the word used here is a person who is unable to understand the question put to him and not able to give a rational answer to the question. It may be because of two reasons. First one is either because of your tender age. Tender age is different from minor. Similarly, extreme old age. So extreme old age is a question of fact. And disease, a disease may preclude you from giving an answer. Suppose you are in a coma stage. You may not be able to understand the question. You may not be able to give rational answer to the question. And this in the opinion of the court is whether of body or of mind or any other cause of the same. So similarly, every person is a competent witness. Every person is a competent witness unless he cannot understand the question put to him by the court. By the court include by the counsel. And first thing is, even though he understands the question, for example, I am asking a question, did you see that the person stand in the box beat the other person? He understands the question, but he cannot give a rational answer to the question. The difference is the word rational answer. He will give an answer, but his answer is not a rational. And what are the reasons preventing him from giving that rational answers? The first one is he is of extreme old age, tender age. Then some disease, either because of the mind or because of the body. Mind എന്ന് പറയുമ്പോൾ we understand എന്താണ്? He may be a healthy man, but his mind is not in a position to understand the question. He is simply an idiot. He may be a lunatic. He may be an eccentric person. And he may give any answer, unexpected, unnecessary answer without understanding the question. Similarly, if a child comes before the court, for example, a child of 5 years is the sole witness of a murder case. We know that nothing is an offense done by a child below 7 years. But a child at the age of 5 is a competent witness. And the court requires to consider two things. First one, whether he can understand the question put to him. Secondly, whether the child is able to give a rational answer to the question. Okay. So in order to understand whether a child below 7 years or a child usually not able to, or the court is of the opinion that he may not be able to give answer to the question, will be asked some simple question to understand whether that child is able to understand the question. And this is a test. And the test is called VIJI-S test. VIJI-S test. The object of VIJI-S test is to identify the capacity of the minor. The person prima facie appears to be incompetent witness, whether he can be considered as a competent witness or not. If the judge, by applying VIJI-S test, is satisfied that irrespective of his extreme tender age, irrespective of the fact that this person is of extreme old age, is understanding the question put to him, he can give rational answer to the question put to him, he is a competent witness. So VIJI-S test simply means some simple questions are asked. Those questions are asked not with the purpose of understanding the general behavior, but whether a child at the age of 6 or 7 can understand the question. For example, suppose a child at the age of 5 comes before the witness box. The court asks simple questions. In which class you are studying, or are you studying in school? Can you say who is the name of your class teacher? What are the subjects? What you learn from the school? Who are your friends? So such simple questions. Such simple questions are asked only for the purpose of understanding whether a child can understand the question. If a child at the age of 5 or 6 is expected to give some rational answer to those questions, if a child at the age of 5 or 6 cannot give any answer to such question, for he simply stare at the judge, laugh at the judge, simply silent in the witness box, the court may be of the opinion that I don't think he is a competent witness and capable of giving evidence. So first of all, let me conclude, due to positive time, the scope and extent of section 118. 118 simply says every person, there is no bar for a particular person to be a witness. A person may be a minor, a person may be in a mentally unstable condition. A person may be suffering from some disease that prevent him at the first flush that he is not able to understand the question. But the court must satisfy that whether this person is a competent witness or incompetent witness by putting void dire tests or questions in the name question, simple logical questions. Thus, to conclude, what section 119 says, every person is competent to testify unless he cannot, first layer, understand the question put to him. Second, he is not able to give rational answer to the question put to him. And the reason for not understanding the question or giving rational answer is because of two diseases. The first one is of his mental disease. The second one is because of his physical disease or physical inability. And his physical inability is caused by two reasons. First one, extreme old age or tender age. Those two, except the said disability, every person is a competent witness. In order to clarify the doubt, if any, section 119 further makes it clear that dumb witnesses are witnesses. Dumb witnesses, we know, are not able to give sound or oral reply, but by visible representations, they can give logical answer to the question. So a dumb witness is also a witness. Hope you understand the first layer, who is a witness under section 118 and 119 of the Evidence Act. Okay. Thank you. Now I am going to the second layer. This can be divided into two parts. Actually, section chapter 9 is dealing with those persons who are excluded from giving evidence or who are prevented from giving evidence. And chapter 10 actually is dealing with the examination of witness. So I'm a little bit confused whether to continue this section or straight away jump into the examination of witness. I am leaving to your choice. In the sense, chapter 9 dealing with witnesses, then who are the person not bound to give evidence, or those persons excluded from giving evidence. And chapter 10 is dealing with examination of witness. I think we can continue with the very same section today, and thereafter we can go to the examination of witness. That may be proper. I think so. So most of you are aware of the fact that section 120, yes, thank you. Section 120, popularly known as matrimonial communication. And matrimonial communication says that in all civil proceedings, the parties to the suit and the husband or wife of any party in the suit shall be competent witnesses. I'm reading it again. In all civil proceedings, the parties to the suit and the husband or wife of any party to the suit shall be competent witnesses. Section continues. In criminal proceedings against any person, the husband or wife of such person, respectively, shall be a competent witness. In criminal proceedings against any person, the husband or wife of such a person, respectively, shall be a competent witness. So here, this section, matrimonial communication, is having two layers. The first layer specifically says that the husband is a witness against wife, and a wife may be a witness against husband.
The different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is, I think, is a constitutional